Welcome to the Human Resource Management Series. The topic of today's video is avoiding age discrimination. I've organized this video as a briefing to senior management to point out specific cases of age discrimination and what the organization can do to help prevent it. This is not a legal interpretation. This is from an HR point of view. I would like to review 3 cases with you today. The first was a $17 million award of damages. In this case, a 55-year-old middle-aged worker was laid off after 30 years with Raytheon. A jury found that the company dismissed him because of his age and awarded him $17 million. The company had a reputation for looking for positions for people before they laid them off. However, in this case, they did not do that. After appeals, the award was reduced to $2 million. The second one involved a 61-year-old man who was dismissed by IBM. He complained to IBM's HR that he was being let go because of his age. The HR department investigated the claim and determined that he had been treated fairly. He sued. The judge looked at the investigation and determined that the HR department did not look into the evidence that the man had uncovered. Instead, the judge believed that the HR department just put a case together to protect IBM. The third case I'm going to discuss in more detail. However, it's apparent from these cases that age discrimination is real and can be costly to your organization. It's worth the time and effort to make sure that people understand age discrimination and how to avoid it. In this case, the company hired a new department head. We will call him Fred. Fred fired 8 people, all over 40 years of age, and he replaced them with much younger workers. All of these people were fired due to performance reasons. The HR manager and Fred got together and put together poor performance review statements based on company policy. They put each of these employees on a performance improvement plan, which they all failed, and they were replaced. So what happened next? George, Fred's boss, fired Fred. Fred was a 55-year-old department head, and George fired him for alleged misconduct. George replaced Fred with a 40-year-old new hire. Fred sued on the grounds of age discrimination and won his case. Fred won his case because he convinced the judge that it was a common practice for George to fire older workers and replace them with younger ones, and the judge agreed. George used the same process that Fred used to fire those 8 workers. The main problem here is that the checks and balances put into place were only followed so far. The department head was most likely doing what his boss was doing. Training and process improvements can reduce the possibility of this occurring. Prevention. Understand the law. Companies need to understand the law in order to make sure that it is followed. A training package should be either assembled by the corporation or an outside firm that can be provided to all employees. It must be mandatory that all employees are trained to understand what the law is about. The areas that are mainly affected in litigation are recruitment, appraisals, and denied training due to age. The Age Discrimination in Employment Act was passed in 1967, and it protects 40-year-old and older individuals from discrimination in all areas of employment. It is illegal not to hire someone because of their age, as well as it is illegal to fire someone because of their age. The overriding factor here is how a company treats the protected class, those over 40, with the rest of their employees. Now, there are defenses. The bona fide seniority system provides for a seniority defense. For example, in a reduction in force, a person aged 45 is let go and a 35-year-old was kept. The 45-year-old was with the company for 2 years, where the 35-year-old was with the company for 10 years. They were both rated the same for performance. The company had a published policy that states that all things being equal, the person with the company the shortest time is the first to let go. The bona fide occupational qualification defense provides for protection to the general public and where a person's age could be a threat to the company. For example, police and firefighters could be forced to retire at a certain age due to the effect of age on performing their duties. The forced retirement of executives at 65 is another court-accepted exclusion. A bona fide benefit plan is where a company distinguishes between people over 65 and under 65. They provide a reduced benefit in terms of medical coverage due to the fact that 65 and older people are qualified for Medicare. The good cause defense provides defense for individuals related to disciplinary action. This action is usually associated with the next defense, reasons other than age. In all cases, these defenses will protect companies from frivolous lawsuits, but they must be backed up by fact and provable. Your company's HR policies in recruitment, appraisals, and training, which is part of your people management system, must be free of any talk of age and be applied to everyone with the only exceptions that are documented in your policies. In summary, age discrimination cases are real and costly. Corporations must bring their HR policies up to date. Promotion and firing decisions must be well vetted, and in all cases, communicate. Everyone needs to know how each manager is dealing with each of their employees. Attention to processes and oversight will help secure compliance and reduce the chances of litigation.